Welcome to the 2025 Overton and Lavona Currie Lecture hosted by the Center for the Study of Law and Religion. My name is Whitney Barth. I'm the Executive Director and the Charlotte McDaniel Scholar here in the Center. And on behalf of the Center and my colleagues, I want to extend a warm welcome to all of you. Some of you have traveled quite far to be here. Some of you have traveled from across campus, which can feel very far, especially on a gloomy day. But we're delighted to have you with us. We're especially glad to have members of the Currie family here to celebrate this event with us. So we're very grateful for your presence here with us this afternoon. So thank you for being here. Our center, as many of you may already know, is an interdisciplinary center, nonpartisan and academic in its focus that aims to produce and promote path-breaking scholarship, teaching and training, and public programs on the interactions of law and religion. This is now our 43rd year of operation here at Emory, and we're delighted to continue to go strong in encouraging these dynamic conversations around pressing issues and also perennial issues in the study of law and religion. Our home is at the law school, but we serve both the law school and the broader university, as well as the broader public. And so we're delighted to have you be a part of one of our programs this afternoon. If you haven't already, I would encourage you to sign up for our listservs to get more information about the center and our work throughout the year. And I'm always happy to answer questions about the work that we do throughout the year as well. A moment to say a little bit about the Overton and Lavona Currie Lecture Series in particular. The lecture series was actually founded in 1986, so one of the early programs of what was then the Program in the Study of Law and Religion, with an endowment from Overton and Lavona Currie, and past speakers have included President Jimmy Carter, Archbishop Desmond Tutu, John C. Noonan of the United States Court of Appeals, and many other distinguished scholars and practitioners. So we are grateful to have Dr. Dana Lloyd as a part of that distinguished group of speakers. We're grateful to her for being here, not only this afternoon, but all week. She's been in residence with the center and engaging with our faculty and fellows. So we're very glad for her presence here on campus. Before I turn to introducing Dr. Lloyd, I'd like to say a few thank yous. Events like this don't just happen. They're the work of multiple hands, and we have a great team within our center. I'd especially like to thank Miss Amy Wheeler, coordinator extraordinaire, for working on so many different aspects of making this day possible. I'd also like to thank Ms. Catherine Loftus for her work on this program, as well as Dr. John Bernal, who's here in the front row and working with us on tech for his role in this event as well. And we also have worked with wonderful undergraduate students, and two of them were involved in this programming as well. Urvi Valaparetti made the poster, and Maria Sokolmanova is helping today with logistics. So we're very grateful. If I could just ask for a round of applause for our center team, I would be. So thanks so much to all of them. Finally, I'll turn to introducing our speaker, Dr. Dana Lloyd. She is an assistant professor of global interdisciplinary studies at Villanova University and affiliated faculty of the Center for Peace and Justice Education. She is the author of Land is Kin, Sovereignty, Religious Freedom, and Indigenous Sacred Sites, published by the University of Kansas Press. She's also written a number of book chapters and articles on landmark Supreme Court cases involving Indigenous religious freedom issues and on the study of religion and ecology, among other topics. She holds a PhD in religion from Syracuse University and an MA from the Department of Philosophy, an LLM and LLB from the Faculty of Law at Tel Aviv University. So we're delighted to have her with us this afternoon. She will give her lecture, and then we'll have ample time for questions and answers. We'll bring up the lights at that point because there are microphones towards the back, and we invite you to form a line to ask your questions at that point. So without further ado, Dr. Lloyd, I'll turn it over to you.
Hi, everyone. Thank you so much for being here. As Whitney said, I've been here. I'm spending the week here, and it's been such a delight. I've been telling people I'm not planning to leave actually by the end of the week. This is thanks to Whitney and Silas and Amy and Catherine, and also upstairs the Vulnerability and Human Condition Initiative that also have been engaging with my work. So I don't know, I'm in the middle of a week where is that so energizing and so generative, and I'm very much looking forward to the conversation with you as well. I'm, of course, very, very grateful to the Currie family and very much looking forward to the opportunity to talk to you after this ends. And I also want to tell you that as Whitney said, I live in Philadelphia, I teach at Villanova. I come to you from Lenape land, and I'm grateful to be on Muskogee and Cherokee land here in Atlanta. So I'm going to talk about this book that came out last year, and again, looking forward to the conversation. Let's see. So the place at the center of the book is the High Country, which is a forest of Douglas fir trees taller than 300 feet, where pre-human ancestors called the Wogay live. Indigenous doctors train. Medicine is made and gathered. It is the sacred homeland of the Yurok, Karuk, and Tolowa Nation in Northern California, and it is managed by the US government as the Six Rivers National Forest. It is among the Siskiyou Mountains, again in Northern California, and it's an area that includes sacred sites, including Peak 8, Dr. Rock, Chimney Rock, and Elk Valley. This is the Six Rivers National Forest, and the book is about this place, but the starting point for the book is a legal dispute about it, and I'll tell you a little bit about this dispute. So the Yurok, Karuk, and Tolowa nations protested for decades and then eventually argued in court against the cutting of 733 million board feet of the trees in the high country. The plan was to do it over 80 years, and against completing the final 6-mile section of a logging road that is known to this day as the Go Road, because it was going to connect two towns in Northern California, Gasquet and Orleans. What the indigenous nations argued was that what the Forest Service referred to as a development plan, right? Like they wanted to develop the forest and to contribute to the logging industry. The nations say this is actually going to damage our livelihood and especially our religious practice. Free exercise of religion was granted to them in the US Constitution and in the American Indian Religious Freedom Act of 1978. So the case went through all instances of federal court and eventually reached all the way to the Supreme Court, where it was called Ling v. Northwest Indian Cemetery Protective Association. The nations won in the lower courts and lost in the Supreme Court. So the research question, I guess, with which I came to this case is that, well, one thing is that the Supreme Court gets requests to hear something like 700 cases every year, and it takes about 10% of them. And it seemed really weird to me that they would take a case that's about 6 miles in the middle of what probably for them is nowhere, right? Like in the middle of a forest that I don't know if they heard about or visited. And even more surprising is that it seems like the stakes, like it's such a small ask, right? Like to not build the final six miles of a road, and yet they lost the case. So I wanted to know what's happening there, and I guess part of what drives this question. This is the Go Road today, which is deserted and has not been used. I come to this to these questions from a different settler colonial context. I grew up in Israel, Palestine, and grew up with kind of taking for granted that land is a sacred thing, right? And so the fact that people have to go to court to argue for the sacredness of their land and that it's not granted that they will be heard was something that was also not trivial to me. I also come from a context where there's no separation of church and state, so this is another difference. What else? I guess in the U.S. Perhaps one might say that the only thing that is really sacred is private property, right? So I think that I wanted to read this case both with the baggage with which I come to it, and also thought that in some way, if I manage to understand it, I can understand America better, but I can also go back and understand my own context differently. Um, and so, yeah, so what I argue in the book, I guess in order to answer these questions that I had about the Link case, I had to do two things. One, the first one is that the case has been studied by, I think, every first-year law student reads it today in law schools in the US. And so everyone studies it. There's hundreds of law review articles about it, dissecting the nuances of the majority opinion. Um, uh, People think about it always, I would say, as a case about religious freedom. And somehow this was not enough for me. Like when I read the case with all of this scholarship on religious freedom, something still was missing. And also, while reading the Supreme Court decision and against all the case law is important, I also felt, it wasn't enough. So I did two things. One was that I went and found the transcript from the original trial and all the evidence and thought maybe if I read what the witnesses are saying about the high country, maybe I'll learn something new. And what the expert witnesses are saying as well. And the other thing that I thought might help me is a different theoretical framework with which to read the case. And so bringing in indigenous sovereignty into the mix here, of course, it came from listening to the witnesses, right? That maybe it's a case that's not only about religious freedom, but also about indigenous sovereignty. Um, um, seemed to be productive. And so doing all that led me to argue that in indigenous sacred sites cases, especially when we talk about, I was talking to Saris's students yesterday and some questions came out that was helpful in thinking about it, but the fact that this is publicly owned land, that this is government site is important, right, to the analysis of the case. So in cases like this, what happens is that religion and property become two competing rights that seem to be mutually exclusive. Either it's sacred or it's property. We can't really allow the high country to be both. But when I read all the materials related to the Link case that I will talk to you about, actually land seems to play many more roles beyond being property, beyond being sacred. And I want to argue that all these roles can live together. They don't have to be mutually exclusive. Of course, if we do buy into the competition between religion and property, property is going to win, right? It doesn't matter if, as we'll talk about, as the court says, we do believe you, indigenous nations, that this land is sacred to you and that your religious practice depends on its integrity. But also this is government property, and we can't help you, right? But then, so when I read a little more, I guess broadly, maybe the two can live together. And I think that understanding land more broadly and allowing it to play more roles ultimately leads to a more just treatment of the land and the people who rely on it. So the book has 5 chapters, and each chapter reflects a conception of land that I think plays a role. In the Link case, it's background and its aftermath. So land appears as home, as property, as sacred, as wild, and as kin. And the first chapter does begin, the first people you hear in the book are the witnesses in the case, the indigenous witnesses mostly in the case, and what kind of story they tell about the high country. This is a tiny, tiny piece of the testimony of Loena Brantner, who was a Yurok elder from a very prestigious family. And she says, I'll say, I guess, before I go into her testimony, that what's interesting in this trial is that it was 2 weeks, which is a very long trial, which means that there's thousands and thousands of pages of transcript, and that the judge was very sympathetic to the witnesses. I think, some people who were there say he was around the same age as these elders, and he was Judge Stanley Wigel. Um, uh, was very progressive and really wanted to hear the stories that they had to tell. So a lot of the testimonies feel more like, long speeches. It doesn't, like if what we imagine, I guess we're at a law school, so we don't just imagine, but like if there are people who without a courtroom experience, like what you see in TV drama, legal dramas, right? Like how you imagine a cross-examination and all that. It doesn't read like that. Like the judge, first of all, does a lot of the questioning, and again, let them talk and talk and talk, and seems very open to hearing things that don't fall directly into the religious freedom framework through which he's supposed to decide this case. So Loana says, we didn't know that the BIA is the Bureau of Indian Affairs, even though we had a treaty, which we didn't know later that it was not ratified. We gave all we had promised, way beyond the mountains, for them and for the land that we were to have in there to keep our homes. In that way, we lost everything, and we are standing on the last peak. So this is responding, I guess, to what the government says, part of what the government says, or maybe I should say something about religious freedom cases, sacred sites cases, maybe in particular, is that what this is early 80s, so the Sherbert test is basically controlling the case, right? So the indigenous nations, if they say this is sacred to us, our religious practice relies on the integrity of the place, they have to prove that this is a sincerely held belief, meaning that they have been using this area for religious practice, for religious purposes for a long time, right? That what the government is proposing to do, cut down the trees, build a road, right, is going to severely harm their ability to practice their religion there. If it goes through, if they're convinced the court, then the government has a chance to argue that there is a compelling government interest in the development plan, and therefore, even though it's going to harm this religious practice, and even though we have the First Amendment protecting religious practice in this way, the government can do it, right? So this is the situation, and what the government says is, one, you haven't been using this area, or not that many people go there, right? Like it's not like you're using it all the time. And secondly, you have other sacred places. This is not the most sacred place in your religion, right? Like that's what the anthropologists tell us. So what Loana Brantner is saying here is basically bringing the settler colonial context and history into the story and saying, you're right, we have other sacred places, but you already took them and you burned them and you killed us and you made us leave. And this is our last place that still has integrity that we can still use. There's also a conversation about what it means that not that many people use the high country, right? Like not, obviously, I'm not supposed to go there. I'm not Yurok or Karuk or Toloa or Hupa. The Hupa people also are in this, even though they're not part of the case, they are people of this land. Um, so I'm not supposed to go there, but not every local indigenous person is supposed to go there, right? Like you're supposed to be either a religious leader, a medicine person, or to get to be called by the great spirit or creator or whatever you want to call it, to go there. So you have witnesses telling stories about being called to go to the high country, and I guess as you saw the road, like part of it, the fact that it's a forest, is that it's not very easily accessible. This is why the government, to begin with, wants to build this road so that people can access it. And so part of what witnesses are saying, and the judge asks them, like, if you get a call to go there to pray, for example, someone tells a story about his son who had a really um, uh, uh, serious car accident, and it looked like he was going to die, and he got a call from the creator saying, you need to go pray in the high country. Um, and he went, and he says, this was years ago, and my son is, still alive. But the judge tells him, but like, what if it's the middle of winter and you can't walk there? Like, what if it's not accessible? And the guy says, well, like maybe I would die, but if my son's life is what at stake, I would try. But this is exactly the point, that it is not accessible. What we don't want Yurok, Karuk, Toloa people say is for the place to become accessible. Part of the religious nature of the place is this inaccessibility. Okay, so and what Loana says here also is, right, like we're standing on the last peak. And also all of these things that we've been doing to protect this place is not only about the sacredness of it, but also because this is our homeland. This is our home. What she refers to as the treaties that weren't ratified. California Indian nations signed 18 treaties with the U.S. government, and then with pressure and started, treaties that meant that they agreed to give up some of their land base in return for all sorts of things, mostly protecting them from white settlers who were very violent. But pressure from white settlers meant that Congress didn't ratify any of the treaties. So this is also part of this story, that if the case is a religious freedom case, there's no room to to tell this story. It's not part of, supposedly this is not a part of what the court wants to hear. Um, so so the fact that the judge lets the witnesses tell these stories and no one says, like, no one objects, right? Like, I think is really significant, at least to my reading of the case. And then what I do with these testimonies is thinking about how the indigenous home was, or even has been, right, maybe still is, a site of oppression. Um, this includes both going into the indigenous actual home and taking children into boarding schools and things like that. It also includes more discursive ways of marginalization and oppression, right? Like in federal Indian law, indigenous nations are considered domestic dependent nations, which means that they are not really sovereign, but they're also not really US states. So this kind of like idea of domesticating, both domesticating the savage Indian, right, like this kind of language, domesticating in the indigenous nations, and the real they're going into real indigenous homes and destroying them. So when the witnesses say this is our home, and it's against all this background of oppression, or through the site of the home, um, uh, I think there's something really powerful here. Then the next chapter goes into the Supreme Court decision, and I start with the majority opinion written by Justice Sandra Day O'Connor. And again, just a tiny bit of her words. She says, whatever rights the Indians may have to the use of the area, those rights do not divest the government of its right to use what is, after all, its land. And so I think this is a really representative sentence. It tells us that even though, again, like the case is about religion, in the trial level, right, like the judge entertains everything the witnesses have to say about actually the land is home and not the land is sacred. O'Connor really cares about the aspect of this land as government property, maybe more so than she cares about the question of sacredness of land. Um, there's all sorts of things I could say about this quote. The choice to say Indians rather than Native American um, or indigenous. I guess this is 1988, so I don't want to also like be anachronistic. This is the law. This is the language that the law uses. But you could also use the names of the specific nations that are in front of you, right? Um, other things that the majority opinion does is that it starts the story of, like when Supreme Court started the decision with kind of like the background, the history of the place. She starts in 1977 when the first development plan was put on the table by the Forest Service. And I feel like, there's so many alternatives. You can start with Yurok and Karuk creation stories. You can start with contact in the early 19th century. That's when Northern California is being settled. There's all sorts of things you can do, right? Like, I mean, the fight again between, or the, like, yeah, I guess the fight between the nations and the Forest Service had a much longer history. They didn't start in 1977 when the official development plan was on the table. It started before that. So I, I guess questioning how come that the high country is on federal land and not part of any reservation, that goes back to the treaties that were not ratified. At this point, the Yurok tribe is not recognized by the United States as a tribe with everything that comes with federal recognition. Um, they refuse to organize in a way that the Bureau of Indian Affairs wants them to, and therefore they don't have this kind of recognition that allows all sorts of things. But yeah, so all sorts of questions that the court does not ask, and which makes it really easy to decide. It makes it really easy when you read this as one of the first sentences uh, in the decision. It makes it really easy for the reader to know what the bottom line is going to be, right? I'll just say that property as a site of oppression of native peoples, right, has again to do with this question of or discursive legal move of domesticating the Indian, thinking about the Indian as savage and as someone who cannot cultivate land and therefore cannot own property. Again, this kind of play we can see here. The third chapter goes into the dissent in the case written by Justice Brennan. And for Brennan, the sacredness of the land is at the center of how he's thinking about the high country, the Go Road, the case. And so one thing that he, again, just to tell you one sentence that he says is that because of their perceptions of and relationship with the natural world, Native Americans consider all land sacred. Part of me really likes Brennan's dissent, and I obviously think you can guess that I think that it's much better than the majority opinion, and that the outcome had Brennan been deciding the case right, the outcome would have been better. But I also have some issues with it, and one of the issues is how he kind of essentializes and romanticizes indigeneity. Again, there's no reference to Yurok, Karuk, and Tolowa people. There's no reference to the high country. All native people consider all the land sacred. This causes all sorts of problems, but I think that one, for me, the worst thing that it does is that it depoliticizes these questions in a way that again allows for actual the link decision to stand. There are two things that if I had to, if I were sitting there, right, like two things that I would want to say about what it means to argue a case about an indigenous sacred site in the United States as a religious freedom case. One is that is the what is known as the civilization regulations, which were in place for about 50 years, not that long ago. Um, uh, but I'll tell you what they are. I guess it's almost 100 years ago, but right, like it's 50 years before the Link case. Um, these are legislations that made practicing indigenous ceremony illegal in the United States. And so when part of what religious freedom law asks for a religious practitioner to prove is that there has been a tradition of using the high country for religious purposes, for example, right? Like you've always been doing the ceremony in the same way, and therefore, if the government proposes to some kind of a plan, right, that or program that doesn't allow you to continue it, you can prove that you're going to be harmed, right? Indigenous peoples have a hard time proving this because there were so many years where they were not allowed to practice their religiosity in this way. So not taking this into account, telling a story about sacred land without saying, well, 50 years ago they couldn't do it, or if they could, they did it, underground, or pretended, like celebrated their ceremonies on Christian holidays to pretend that it's Christian ceremony, right? Or I mean, I think people did all sorts of things to deal with it, but for the court not to even acknowledge this history, I think is problematic. And then the other thing that is erased in this dissent, or in the case as a whole, is that the American Indian Religious Freedom Act, which is again one of the things that the Yurok, Karuk, and Tolowa nations rely on in their original lawsuit. It's a law from 10 years earlier, 1978, and it's a law that is uh, has been described as having no teeth in it, right? So it only requires it. It sets the intention to allow indigenous peoples access to their sacred sites, and it asks or requires consultation in cases where the government, for example, wants to do something to an area that's significant culturally to indigenous peoples, but it only requires consultation. So if you do the consultation, which happened, by the way, in this case, and what you learn from the experts and from the indigenous residents of the area, it doesn't matter what you learn from them. You don't have to follow through, right? Like the only thing that you need to do is to go through the consultation. And what we know, if we look at the history of this law, is that the reason for this law to not have any kind of like mechanism to actually enforce it is that they knew the Forest Service, like they knew that the Link case is going into the courts, and they wanted to make sure that it's not going to affect them. So again, deciding this case without knowing or acknowledging this history, I think, does something to indigenous religions that is just as bad as deciding for the government and against the nations. The next chapter looks at the California Wilderness Act, which actually, I'll let you know, that even before the case got into the Supreme Court, included the high country, or most of the high country, in the wilderness area of California, meaning that by law, the Forest Service cannot cut down the trees and cannot build the road that it wanted to build in the high country. So the high country is protected. The case is moot before it goes to the Supreme Court. Brings me back to the question, how come the Supreme Court took this case and how come it was so important to them to decide it the way that they did. But again, so what happened was that the litigation of the case, right, like originally The original plaintiffs are indigenous people and grassroots organizations from Northern California, as well as some environmental organizations and the state of California. The environmentalists, when they see, at the same time as the litigation, they have money and they have their strong lobbying, and they lobby to include the high country in the California Wilderness Act, and they succeed. And so this is great, right? So you saw the Go Road. It's not like it's nothing. But also, because I'm grumpy and I want to find problems with everything, um, I have an issue with calling the area wilderness. So as you know, wilderness is an area of undeveloped federal land, retaining its primeval character and influence without permanent improvements or human habitation, which is protected and managed so as to preserve its natural conditions. This means that no one has ever been in this place and made any, like no human has, lived there and made an impact on the place. This erases Yurok, Karuk, Tolowa, Hupa nations, right? Like it goes back again to this idea of the wild, savage Indian, right? Like we don't think of we don't think of them as people who can actually cultivate land of the mark that they live on the land as something significant. They can't make it into property. It remains wild. They even brought, the government even brought a wilderness expert to the court, which is just this guy who traveled extensively, went to the Himalayas, went to the high country several times, and I guess it's not the government who brought him, it's the state of California who brought him. But I mean, if you know anything, then you should know that you shouldn't go there if you're this non-indigenous person who just likes to hike, right? So I don't know. I have issues there too. Another problem with wilderness is that it attaches the land to the government, not to the indigenous peoples, right? Like this is again, it's public property. Now I'm running out of time, so I'll just tell you about the last chapter, which is looks at the aftermath of fleeing and things that have happened since, much more recently. So in 2019, the Yurok, so since Ling, the Yurok tribe organized according to the tribal reorganization, the Indian Reorganization Act, and established a tribal court and a tribal government that has been doing really amazing work. And in 2019, they issued this resolution to acknowledge to recognize the Klamath River, which is, and this is the Klamath River, and this is how it's entangled with the reservation. So the reservation is just like this 44 miles along both edges of the river is the Yurok Reservation. So it's really entangled together. And the resolution recognizes the Klamath River as a rights-bearing person, which gives it standing in court and the right to remedies, right? It says the Yurok Tribal Council now establishes the rights of the Klamath River to exist, flourish, and naturally evolve, to have a clean and healthy environment free from pollutants, to have a stable climate free from human-caused climate change impacts, and to be free from contamination by genetically engineered organisms. A really important thing I think, or to my reading, a really important thing that this resolution does is that it gives the Yurok Tribal Court jurisdiction over cases. So like if you harm the river, right, if you do anything to harm the river's right to flourish and to be clean, right, and healthy, you would go to tribal court. You would not go to federal court. Isn't this a declaration of sovereignty, right? Like we're not coming back to you, U.S. federal court. We have our own court. Now, the biggest thing about the Klamath River and its issues is that it has 4 huge dams all over it, right? And the dams are run by or owned by Pacific Corp, which is a Warren Buffett corporation. And I read this when it comes out, and I think this is amazing. Like this is so cool that they're doing it, but also I can't imagine Warren Buffett walking into tribal court. It's not going to happen, right? So theoretically, this is really, really cool, but I don't know that it has any real implications. Yet, somehow, I'm skipping, but the dams are falling. All 4 dams have been removed by now. 2024 was the last dam, so 5 years. And this is again a fight that telling you is like a snippet of it, but it's been decades of fighting to heal the river, and something happened there, right? Like so, it's hard to say that it was um, a direct result of this resolution. But what happened also was that the state of Oregon, the state of California, and tribal nations came together to purchase I mean, Warren Buffett got a lot of money out of it, but the plan is to work for now several years to heal the river, bring back the fish that are also part of Yurok and other tribes, local tribes, spiritual life and economic life, right? And so I don't know, it makes me really happy that I can end this on a more hopeful note, right? Like I think we've been talking about so many depressing things in the past few months. And this is actually, I'm grumpy and I have all this criticism about the link case, but I end with something that to me is really, really happy. And yeah, I think I'll stop here and I'll take questions, and I can talk more about whatever is interesting to you.
Worked. Great. If you have a question for Dr. Lloyd, please proceed to the microphones behind the first section, and take questions as they come. And if you're online, you should be able to see the Q&A.
Hi. Yeah, thank you. Thank you for this opportunity to talk about it a little more. So there was, I think in the very early 2000, there was a lawsuit that led to the Klamath Agreement. So the agreement to remove the dams or to work toward removing the dam has been in place for like 20 years before it actually started happening. And I think, like I've been in touch with Yurok people, and every couple of years they say this year it's going to happen. The interesting thing about the Klamath agreements is that they do acknowledge the status of salmon as sacred to Yurok and Klamath peoples in the agreement. So, this is also pretty cool. I think the states, I think when we, federal Indian law, right? Like its point is that states should stay off tribes. Only the federal government can deal with tribes, and this is supposedly, and again, this is kind of like part of this infantilizing thing, right? Like to protect tribes from states, which may be true. I mean, we're here in Georgia. We know the history. I think the states of California and Oregon were really on board for various reasons, environmental, but also from related to respect to for the tribes. And so during pandemic, the two governors agreed to put the money, the money into this, and Pacific Court agreed to hand over the dams again over 4 years, and all four dams by now have been demolished. So it's not the end of anything, right? Like there needs to be a lot of work to take place in order for the fish to start coming back and for the natural uh, um, plants to grow back and for the river to. But again, like this is happening.
Yeah, hi, Dana. This is great. I really love your argument. I think you highlight the issues with the discourse of religious liberty, religious freedom. I just have a question. I took some notes on my phone here. Do you have any thoughts that there's sort of a gendered aspect here when it comes to the denial of the rights of these three California Indian tribes, for lack of a better term, when it comes to this space? We were just having a discussion among the faculty earlier today, and the discussion was we have a very Supreme Court that seems very high, very eager to defend religious liberty, religious freedom, and yet maybe at the same time is trampling underfoot sort of women's rights and women's empowerment, and is showing maybe a callous disregard at the same time for that. And I'm just wondering, there's events of the past few days, like there was a body of a 14-year-old San Carlos Apache member found in Arizona. And, of course, the San Carlos Apache, there's been this huge battle over the Oak Flat region, where there's an attempt to build a mine, copper mine. And what's Oak Flat used for? Puberty rituals. And, we can think, does settler colonialism have this gendered aspect? We think about the expression, the court of the conqueror. When we reflect upon law as violence, genocide, and sort of allowing for this, uh, can sort of the mysteries regarding why the Supreme Court, why the US court, the court of the conqueror doesn't seem to show much concern or solicitude for indigenous religious freedom, kind of have this gendered aspect where, again, indigenous peoples are kind of lumped together as bodies or property that maybe not the male patriarch, but maybe the state, the settler colonial state, can sort of trample afoot. I think about there was an eco-feminist, really a luminary in feminism, Petra Kelly, who was a member of the West German parliament at this time in the late 80s, and she was writing letters on behalf of the Western Shoshone Nation. And she referred to the Supreme Court at this time, the Rehnquist Court, as the new 7th Cavalry, which is General Custer's unit. And I think it's fair to say, yeah, we're seeing this sort of trampling here, and perhaps this link of equality and women's rights and all has a bearing on all this. Anyway, that's a lot there, but great job. Yeah.
Yeah, thank you. No, I love this question. I'll say the Klamath River is also a site for the flower dance, which is a coming of age ceremony for girls, um, mostly hoopah girls, but um, obviously these when I talked about how indigenous ceremony was outlawed, right? Like the late 19th, early 20th century. I will also say that even beyond this question of legality, this was it became really really dangerous for girls to go into the river and do the ceremony, because that was when settlers came in and kidnapped, raped, killed them. Um, and so the flower dance has been revitalized in the past 10 years or so, which is also uh, a great thing that's happening around the Klamath River. The second thing that I'll say is that I also didn't talk about it today, but it is the people who train in the high country are medicine women. So when Loana Brantner, who is a medicine woman, or was a medicine woman, testifies in court, it's huge. But when you read all the documents, the fact that it's medicine women and not medicine people or medicine men is totally erased. And maybe last thing that I'll say, that when I interviewed Yurok and Karuk activists, and like people, witness people who were involved in the activism and litigation of the case, they talked in this gendered language all the time. Like what's happening is that the land is being raped. That's the language. So yeah, I think that this is absolutely the case. It would be interesting. I don't know how, like, to, I'm saying this is a case about religious freedom and there's no room to talk about indigenous sovereignty. In a way, there's also not a way to not room to talk about gender in these cases. I know people have been really hopeful for Oak Flat to reach the Supreme Court, and with Gorsuch, maybe there's like some hope. I'm not one of them. Yeah, thank you very much for this reading. Hi.
Dr. Lloyd, I really admire your courage and your creativity in trying to give us better understanding of this nuance for our Indigenous brothers and sisters. But I'd like to ask a question about something that I think you mentioned almost in passing. Early in your book and then later, the development by the Yuroks, I think it was in the early 90s, of their own tribal councils based on the Reorganization Act. But that was, if I'm reading it correctly, back in the 30s. I wonder if you could consider more development of the councils, almost like an infrastructure, a context in which your work could really be housed and then brought forward with even more robust support. Wonder what your thoughts might be about that.
Thank you. Yeah. So what's happening is that you're right that the Indian Reorganization Act is 1934. By the way, this is the act that ended the civilization regulation. The Yurok were engaged in a different legal battle. It took about 30 years. It was related to revenue issues that I don't know much about. It's called the Jesse Short case, if anyone is really interested. And what happened, and I guess this is also related to the Klamath River, because what's happening, kind of like starting around the maybe 1945 and also lasts 30, 40 years, is what is known as the fish wars. So there's one thing that's happening at the courts is this revenue related case. Other thing that's happening on the ground is, and also in courts, is the fight for fishing rights around the Klamath River, but not only. The BIA doesn't let, even though the court says, yes, Yurok people have the right to fish in the Klamath River. The reservation has never been, like, this is Indian country and they have the right to fish. There's still a lot of violence on the river. The BIA basically says, we want you to reorganize based on the Reorganization Act. And the thing that the Indian Reorganization Act does, even though again it's good, like its point was to stop violence and erasure of indigenous peoples, but what it calls for is for tribes to reorganize based on the US as a model, right? Like to write a constitution that is like a US constitution, to have a government structure that is like the US. The BIA really wants the Yurok to do that. The Yurok say, we're not going to do this until we settle the Jesse Shore case, until you give us these revenues. It takes 30 years. In 1993, this case is settled and the Yurok organized. Now, I talk about the Yurok people as if they are one thing, but you talk to Yurok leaders and you'll see that some of them are really into this kind of like government structure, collaborating with the county, with the state, with the different municipalities, right? Others say, I don't want anything to do with federal government or anything, right? Like, don't want to talk to settlers, working through different avenues. So you're right, this is really, really important. It's really rich. It's in chapter 5. And yeah, I mean, I don't know, I told Whitney that if she's not going to make me shut up, I might talk for 2 hours. So but this is one of the things that didn't come up today, but thank you for asking it then. Hi, Silas.
As you noted, kind of talking about what got you interested in this project, to think of land as sacred is to give it a completely different conceptual framework than the one that we commonly operate with in the United States, right? To imagine land not as property, but as sacred is to imagine an entirely different conceptual framework. And you've shown the problematic with that as well, particularly in the way in which Brennan deploys it in the Descent to Ling, kind of flattening out all land and all forms of indigeneity and indigenous identity. Um, and what I'm curious, what I would like to hear you talk more about is what happens then when we think about land as kin. So to think about land as sacred is a massive conceptual move from land as property, but what does land as kin do differently or beyond land as sacred?
Thank you. Yeah, this is great. I think what the kinship idea does actually in the bottom line is to allow, I think it's a really capacious concept, and I think it allows for property, sacredness, wilderness, home to live together within it. The kind of like example that I give, my daughter is right next door, and I always say, you know, like if someone took my daughter from me, I would do anything to get her back, and I wouldn't say, well, this is not property, so I'm not going to pay money. Like I wouldn't care, right? Like, so you see this struggle as something that's so rich, and it's I talked with the students about land back and the different forms that land return initiatives take, and sometimes it involves giving a lot of money to sketchy institutions, right? But it doesn't matter because we get what we get back. What indigenous peoples get back is the right to care for and live with and be cared by their homelands, right? I'll say that the huge jump from property to religion is also not that huge. Like, you know, again, more things that I didn't say. That wilderness is an interesting concept in this context, because I think if there is any, if part of what the religious freedom framework does is that it doesn't allow kind of like for indigenous conceptions of sacred land to be heard, because the way that religious freedom law in the US is designed, it is around an understanding of religion as a Protestant religion. Like religion means my private inner belief or faith, and it doesn't matter if I have access. Like, we didn't tell you not to believe what you believe. So if you can't access the high country, it doesn't matter, right? Like that's not harming your religious freedom. One thing that I think in American political thought and American religious and legal thought that allows for this like sacred land to be at the center is wilderness, right? Like Americans for centuries have been thinking about land, wild land as a sacred space. And I think that, you know, I presented to you a dichotomy here, like, right, like once the Yurok people say, okay, we are asserting our sovereignty, the tribal court will have jurisdiction, we don't want anything to do with US court, this is about sovereignty now and not about religion. If you read the Yurok constitution, if you hear Yurok lawyers talking about the Klamath River and about that resolution, they talk about their original agreement with the creator to, like, the creator gave us the Klamath River and all its bounty, and in return we have to take care of it. So like in a way it is a religious freedom, it's still a religious freedom story, but with Yurok values centered, right? So the leap is not that huge after all. This is, I think, my point, and I think that kinship was what allowed me to see it or to tell it that way. And also, I think that kinship, like one thing that I hope the book manages to do is kinship is another site where the oppression and genocide of indigenous peoples has happened, right? Again, by taking children from their homes, by forcing indigenous peoples to separate into like households of one man, one woman, 2.5 kids, a dog, a cat, and a white picket fence, right? Like in order to keep some of their land. So seeing it become a site of resistance is also something really meaningful to me. And it's the same with the wilderness and the home and the sacredness and property. And I think that ultimately what the book wants to say, again, if we go back to the trial, is that settler law became a site of resistance, because when we look at, we read the testimonies by Yurok elders and Karuk and Tolowa elders in the court, what they do is that they tell their story in a way that brings Yurok law and Yurok religion into the court. And this is now part of the public record, right? So it's part of settler law. And so, yeah, I think, I started with all these dichotomies and ended, hopefully, like without them. Okay. Hi, sorry, you've been waiting and I've been chatting. So.
No, that's fine. Thank you for your talk, Dr. Lloyd. My name is Beth Michelle, and I'm the Senior Associate Director for Emory Center for Native American and Indigenous Studies. So we're just glad to have you here with this perspective, with the legal lens. And thank you also for the gentleman who mentioned Emily, the young girl from San Carlos Apache tribe that was recently lost among our community. I was wondering if you could elaborate a little bit on the comment that you made regarding sort of at Warren Buffett maybe not showing up to our tribal courts. So when I say our tribal courts, I am a Thanatham Nation citizen, and so I see our resolutions, our laws, and our courts in action in various ways, and I wonder, you as a legal scholar and a legal professional, what have you seen in this, your authorship and then in your work that makes you think from that perspective of like, our courts are not taken seriously? And I just ask that as like a curiosity question, and not to say, there's any wrong or right in that statement, but I'm just curious to know. Thank you.
Yeah, no, I'm just, if I can clarify, the courts, you said our courts are not being taken seriously, or they are not taking something
with
that I
the
didn't
comment
hear.
about Warren Buffett might not show up
not
to
going
the
to.
Yurok tribal court.
Yeah.
What's behind that statement?
Yeah, I mean, like it's more me being sarcastic than it's not based on, like, no one called him into Yurok tribal court and he said no. I just did. It's very hard for me to imagine it happening, right? Like with non-indigenous people saying, yes, tribal court can have jurisdiction over us, right? Like the history of settler law shows it out again and again. But I will say, on the other hand, right, like the Yurok tribal court again has been doing awesome work in all sorts of areas, including domestic violence, for example. And what I know is that the county and the municipalities around, I think also the state of California, are sending people whenever they can into Yurok. They're holding all sorts of like group therapy for violent partners and all sorts of things like that. And they're very good at keeping people outside of any kind of incarceration. And I think that again, I said, like, there's the federal government thinks that it's good for indigenous people, that it's better than the states, but I think locally on the ground there's relationships where people do want to go to tribal court, and they do, and that other judges and other officials know that the tribal government is doing amazing work that often the county can't do or the state can't do. So when I said, like, I started with all these binaries and dichotomies and I end without them, again, I kind of tell the Klamath Story River as story of a struggle, but it ends with this collaboration, and the healing of the river couldn't happen without the collaboration. So right that I was sarcastic, and I'm not saying that most people or many people would take, most people don't necessarily know that there's still indigenous people right here, right? Like, so, but I think that the people who are actually on the ground and know the work are really respectful of it. And yeah, so it's not exactly responding to your question, but that's what I have. Thank you so much.
Thank you so much. Um, we would like to invite you out to the Hunter Atrium to share a bite to eat, some snacks and reception. And also Dr. Lloyd's book, Land is Kin, is available for purchase out there as well. So one more round of applause. Thank you all for coming out.